group, and I'm expecting maybe some more people to trickle in, but I'm going to get started. So, small group, but by show of hands, how many of you made it to part 1? Okay, so about 50-50. So, we're going to be, I'm not going to be re-going over everything that I went over in part 1. Part 1 is very important. I did go over a lot of the notice and inquiry requirements. I'll briefly touch on those today. But we're really going to move on into some of the other substantive changes to the law that will be taking effect on January 1st. However, picking up where we left off, for those of you who were here at part 1, this will be a little bit of a refresher, but for those of you who weren't, this is a crash course into part 1. Why does ICWA exist? So, I'm not going to throw it out there because I'm not going to put anybody on the spot, but why do we have ICWA in place? This goes back to the historical trauma. The abusive child welfare policies that resulted in separation of large numbers of Indian children from their homes, their families, their tribes. The Indian tribal termination policies and the Indian relocation policies that really ended up with a lot of tribes losing their stability and security in the future of their existence, which is their children. So the ICWA was created just almost exactly 40 years ago to establish minimal standards to protect the best interests of Indian children and to promote the stability and security of tribes and families. Now you guys do have as one of your handouts Senate Resolution 707, which was just recently passed through the Senate, commemorating the 40th anniversary of the Indian Child Welfare Act of 1978. Why I printed this out for you is because they do kind of go through a little bit the research that was conducted that led to the creation of the Indian Child Welfare Act. They go through the reasons for it being created and the importance of it still existing today and the good work that it's doing. And it does mention, even in this Senate resolution, that over the 40 years since its enactment, it's served as a model. The federal statute has served as a model for many states, including California, which has incorporated and strengthened a lot of the protections that the federal act put in place within our own welfare and institutions code. And that's what we're going to go over today. So I'm not going to read through that, but you have it for reference. It's a good refresher and a nice little tribute from the Senate, small group of people. So then, why do our clients lack the information necessary to determine their Indian status or the child's Indian status? Now, when I say that, how many of you have had a client come into court and say, well, I think I have Indian ancestry. Like somebody told me it was Cherokee one time, way back when. Is that a common experience that people have in this courthouse? Yes. Well, that is because, again, back to these forced relocations and tribal termination policies, a lot of people don't have the information or the connection to their family to really be able to do their own background and check and figure out, am I a member of this tribe? Am I a citizen of this tribe? A lot of families maybe just had one historian who was responsible for keeping all of that information. That person may be deceased, or they may not have a connection with that person. It's still important for us to follow up on it because what this really goes back to is for some tribes like the Cherokee Nation, they're going to trace their membership to the Dawes rolls. You're looking for an ancestor, however far back, who's named on the Dawes rolls, these rolls that were created way back when. So it's important that we still get the information for them and the investigation is done. They may not have it, they may not have everything that we need to determine if the child is an Indian child, but that's why it's up to the tribe. We provide the information through our clients. We empower our clients to understand why this is important and what it can do to help them and protect their rights. And then the department is responsible for the investigation. So what is our role? I kind of discussed that. Most importantly, we're ensuring that our clients can benefit from any and all the protections they're entitled to. Yes, the ICWA does provide a number of heightened protections for our clients, and as we're going to discuss, those start at detention. So it's very important that you're doing that initial analysis with your client to determine if the child may be an Indian child or is an Indian child at the outset, because even when it's undetermined, if there is reason to believe or know, these protections are going to apply to your client from the very first time they step into court. And why does it matter? Appeals, it's the #1 reversed on appeal issue, which usually does not benefit our clients, because then it's like a limited reversal just to check the ICWA notices. Your client gets confused because they think, well, now can I file a 388? No, you can't. We're just reversing this because we screwed up earlier on, didn't do the notice properly. So if it turns out there's no Indian, the child is not defined as an Indian child, that termination of parental rights stays right in place, just as it would have been. Yes?
So when you're going back to when you said what our role is, so we, inform them that they will have, certain benefits. It's a heightened, criteria, and so it would be beneficial to them if they could identify their ICWA Indian background, right? But further than that, do we do the long form like they used to have, or that they use, where you put other relative names on there, or who helps them investigate whether they do have an Indian background? The department, or?
Right, so the inquiry and investigation is really on the court and the social services agency. My Part 1 training went into much greater detail about the, no, it's okay. And I'm happy to share it with you. You don't need to apologize. I just don't have time to go over it all over again, but it went into much greater detail about that. It's really going to be on them at that point, but it is still imperative on us to make sure that when these ICWA 030s are completed, that's the notice form where they go through and put all the ancestral information in there, that we're going over it with our client and kind of doing our own sort of check of that as well, which may feel duplicative, but it's going to make sure that you're getting everything done and checked through the right way the first time, and can ultimately end up resulting in the information being provided to the tribes that may allow them to determine if a child's an Indian child or not.
Thank you.
Yeah. Why else does it matter? Higher burdens of proof we're going to get into. The services that may be available for your client. And then cultural identity and family ties are very important in any case, and also particularly in these ICWA cases. This is just another reminder of one of the biggest reasons we're here. This is from the Smithsonian National Museum of the American Indian Education Office. I did not create this. This is their creation. Just some key concepts to remember in culture. There is no single culture or language. That's important. Just a side note story. In a case that I handled, a very big case, the foster parents ultimately were fighting for placement of this child with their family. The foster parents in that case casually referred to culture as their attempt to bring culture into this child's life as painting a wall in their kitchen, Navajo blue, for this Choctaw Indian child. They also casually referred to a dream catcher that she had made in I believe it was at a Choctaw Nation powwow, as just having ended up in the trash. This was something that was very important to this child, and it may seem like a cultural token or item, and sometimes these tokens or items I would indicate are not like enough. Like, it doesn't mean that if foster parents buy their children, the foster kids, dream catchers and cute little Indian dolls and a book about, that's not necessarily what culture means, but it's important to remember on the flip side that these items can be very important, even though they may seem like just small tokens, or even if in popular culture they've been sort of reduced to decorations or such. Now to the important part that everybody needs to know, and I know this is a small group, but I hope you guys go and share this back with your office, because this is pretty important. It's a complete recodification of the Indian Child Welfare Act statutes as we've created them in the Welfare and Institutions Code. So, as I highlighted at the last training, inquiry and notice, these first two parts here, They've flipped them in the code numerically. So but apart from that, there's also a lot more specific steps that need to be taken by both the court and the social worker in conducting the inquiry. And most importantly, notices when they get sent out. If I say there's no more 60-day rule, do you guys know what the 60-day rule is? What's this 60-day rule that we talk about? Yeah.
You need to give the tribe 60 days to respond to the notice that the department sends out to them, so that they can put their input in on whether or not they want to be a part of the disposition, or whether or not they recognize that family as an Indian family.
Right, so that's no longer a thing. There is no 60 days anymore. It's not a wait and see. It's not notices get sent out and we can proceed on disposition as long as we just wait out the timeline. That's not what needs to happen. It is now an active and imperative effort on the department to be reaching out, making a diligent effort to send the notices, and if they're not getting responses back timely, to try to, sort of like the UCCJA. Think of the UCCJA. The imperative on the courts is they have to at least reach out to the other court, the other court that may or may not have jurisdiction. At least an email or two, a phone call, attempts, reasonable attempts to reach out and receive an answer from those people. That needs to be done now with these ICWA notices. So it should not take the 60 days. Could that take longer if we're leaving it up to the social workers to actually be doing these diligent efforts? Now there's no outer limit. Yes, but that's why it's on us. If you really want to be pushing a case forward, ask for those progress hearings. Make sure that orders are made if need be, if they're not setting progress hearings, and don't be afraid to file a motion for sanctions if you really need to in the right case where the social worker is absolutely not following court orders or doing their job to ensure that ICWA notices are being properly followed up upon. That's enough for the refresher. Now into the new stuff. So emergency proceedings. These are our detentions. So any detention hearing, the notices are supposed to be consistent with the requirements for parents that are set forth in your 290.1 and 290.2. That does include an effort to notice any tribe if they have done their job prior to filing the detention report and asked if there is any Native American or Indian ancestry. So usually they're supposed to do that inquiry before we get to court. And if the parents have said anything, those notices would require reaching out to any possible known tribes for the children. The detention report has to include additional information if it is known or there is reason to know that the child is an Indian child. What's that additional information? It's a long list of things. It's like 9 different things that have to be included, which include a statement of the imminent risk to that child in the care of the parents, among other things, any tribal affiliation, the normal things that we see, the circumstances underlying detention, active efforts instead of reasonable efforts to prevent or eliminate the need for detention, steps that were taken to notice the tribe and or parents, efforts to locate any absent parents, including contacting the BIA, and residence or domicile of the parents, because that can become important for exclusive versus concurrent jurisdictional issues that I'll get into a little later. So there's a lot of specific stuff that should be in a detention report for a child who has suspected Indian ancestry, so look out for that. And that's all newly added. None of that was in there before. Also, WIC 319D says that if the court, it's an additional finding that needs to be made in detention hearings where there is reason to know the child may be an Indian child. So the court may only detain the Indian child if it also finds that detention is necessary to prevent imminent physical damage or harm. And the court needs to state on the record the facts that support this finding. Now, are you going to make this fight on every case where there's a suspected Indian ancestry? Probably not. You're going to assess your cases just like you would with any detention hearing. But if there is reason to know the child is an Indian child, this is a pretty high standard. This does not say emotional harm. This says necessary to prevent imminent physical damage or harm. That's a pretty high standard. So I would use this as a tool for your clients on those cases where you think that you have a good argument for release, or at least a straight-faced one. And then the detention, the emergency detention, is not supposed to last more than 30 days unless some specific findings are made under the code, yes.
What if the report doesn't, contain those things, but when you speak to your client, there is reason to know that the Indian Child Welfare Act should apply? Maybe it's an error on the social worker's part, or for whatever reason when they make that inquiry. Do you ask to have it continued so that the report addresses it in that way, like a one-day detention for that? Or do you have a detention with it not being addressed in the new manner?
Well, I think that that's probably a case-by-case analysis for you, and looking at your case, what's going to benefit your client. The 319D finding still applies. The court has to make that finding, even if that day your client steps into court and tells you that there's reason to know. You file that ICWA 020 form that says that the child may or is eligible for membership in a tribe. If that's filed that day, those 319D findings still need to be made. Now, whether or not the report actually contains the information that was required in it, do you need that information? Can you obtain that information on your own? It would be an assessment on a case-by-case analysis for me. I mean, if you know the residence or domicile of your client and can get that information, if you needed to do a 319 evidentiary hearing, you could always bring in the social worker or have your client testify as to some of that information. If you think that, that information hasn't been properly addressed and it's really imperative to have that addressed, then certainly I guess you could ask for, I don't know that a one-day continuance is going to get that for you though, because are they going to get a report before the court in one day? I think it'd be more like a Dennis H. hearing that you'd want to have that information before. Essentially that they didn't do what they were supposed to do and cross-examine them on these issues.
I'm just like new in the ICWA court right now, and I just didn't know if, because this is changing, is there like a certain procedure that we should be following when we come across a case with those kind of conditions?
So the caveat to all of this is that it is changing, has not changed yet. I don't know how this is going to play out. There's a couple of things we're going to talk about that I am going to be very curious to see how the courts manage it and deal with it if we start pressing the issue. I don't have the answers of how it would play out. I could just give you what my best thoughts or best practices, ideas would be. But my advice is always going to be analyze it on a case-by-case basis. The clients, what's always the most important, what's going to benefit them, what do you get out of a continuance? What are you trying to gain from, is there something to be gained from putting the social worker on the stand or from your client testifying? Or can you argue it on the basis of the information that's already contained in the report, some of which overlaps with the requirements for ICWA cases, and use the higher burden, the additional required finding to get your client a possible release. Okay. There's this brand new code section, 319.4. Don't really know how this is going to work in practice at all. It says basically it gives you the right to an ex parte hearing prior to disposition. So say the child gets detained at detention, the findings are made, but you determine that there's evidence that shows that the emergency placement is no longer necessary. There's no longer a need for detention to prevent the imminent physical damage or harm to the child. So you want to get that information before the court, before the disposition hearing, to have your client's child released to them immediately. How do we do this? Unclear. In the code section, it does say that the Judicial Council is supposed to adopt a form, a Judicial Council form for the execution of this, and I imagine that rules of court are going to be amended to also so reflect how this would happen. Perhaps unless and until that happens, if you have the right case where this is appropriate, a walk-on request, an ex parte motion pursuant to 319.4, submit it to the court and see. But don't get too excited, because it's just the court may, not has to. So you're going to have a lot of courts who are going to say, well, no, my calendar's too busy for that, or I don't think this is sufficient, or we're just going to wait till disposition. And frankly, that's not outside of their purview. Okay, so this is the one that I think is probably the most important for everyone to kind of know about. 352, WIC 352, our continuance statute, now has this new or 30 days in the case of an Indian child language added in there. So now we know the general rule is that disposition should not be continued beyond 60 days absent exceptional circumstances. If it's the case of an Indian child where there's reason to believe or where the court knows or has reason to know the child is an Indian child, it should not be continued 30 days beyond the detention unless there's exceptional circumstances. Now what's important to note is that it says specifically in this code section that the absence of an opinion of a qualified expert witness, which you'll see as we move forward, is a requirement for disposition to remove from an Indian child from their parent. The absence of that opinion shall not in and of itself support a finding that exceptional circumstances exist. So the department can't just say, oh, well, we didn't have enough time to put our evidence together, so we need a continuance. The court can press them to go forward on that without their evidence if that's the only basis they have. Now, you know, if you have a clever county counsel or even just a mildly smart county counsel, I'm sure they'll come up with other reasons why they need a continuance that might be exceptional circumstances, but press them on it if you have the right case. This is a great tool to have because, you know, we have our right to no-time waiver trials, but then sometimes dispositions get continued beyond this. This holds your disposition hearing for a case of a possible Indian child within 30 days. That can be huge for cases where you really want that to happen. How is this going to work? I don't know. You know, it's going to be pretty hard. I know that at the last training I got pressed on the issue of, well, how does this work with notices and timing of, because the notices have to be sent out, the whole investigation in 030 needs to be filled out, they have to be received by the tribe at least 10 days in advance of the hearing. So that puts you at least on, let's be generous and say at least maybe 2 to 3 weeks beyond detention. So how is that going to work? Again, if you think that this is important and you want to keep it on these timelines, make your record. Ask for a progress hearing if you need to. I know that, like, when I say ask for a progress hearing, I get that you may get denied in a lot of your courtrooms, but some of this is about making a record, that you are trying to keep it on the timelines, because the only way to really take up these issues or press the timelines is through emergency writs, which can't be done unless you've made your record for why this case should be moving forward. So if you need to, when detention comes up and you're looking at a no-time waiver adjudication and you want to go straight through dispo within the 30 days, flag that issue for the court and say, Your Honor, I know that this is with an ICWA case, this puts us on a really tight timeline, but in order to ensure that we can maybe go forward, I would ask for a progress regarding the ICWA notices to be set, whatever would be a reasonable time frame for them to conduct their investigation and give them the 10 days for receipt before the hearing. So it should be at least 10 days prior to the hearing. But ask for that so that you can keep an eye on it. And so there's an opportunity to hopefully correct or deal with those issues before you get to the trial date, and then it gets continued way beyond those timelines. Any questions about this continuances issue? No. Anybody surprised by this issue? No? Right to transfer. So just know that in all ICWA cases, there is a right to transfer. The court's going to determine the residence and domicile of the child and parents as defined in the code, and that's why it's important that that's contained in those in the detention report at the beginning if possible, but it should be part of the case moving forward. Important to know that exclusive subject matter jurisdiction will exist if the Indian child resides or is domiciled on the tribe's reservation and the tribe exercises their jurisdiction over those proceedings, or the child is a ward of a tribal court. So again, think of it kind of like its own version of UCCJA, all right? Tribal Entities are sovereign nations. They do have the respect. They are supposed to have their orders and findings are supposed to have full force and effect. So that's what we're looking at here is, whose jurisdiction is this matter contained within? All others are going to be concurrent jurisdiction. So the state court must transfer to a tribal court jurisdiction if there's a request from either the parent, Indian custodian, or tribe. Absent good cause to the contrary. You're going to see good cause come up a couple times in this training. Now just note that your client, a parent, has an automatic veto. One parent, does not take both. One parent can say, nope, I don't want the transfer to tribal court. Done. Dead in the water.
And the minor doesn't have a veto.
The minor does not have a veto. That is just the parent, one parent. It can take only one parent has an automatic veto right. The minor does not have an automatic veto right. And just so you know also, you'll see this happen sometimes where they say, maybe the tribe wants to transfer later on, and then people are like, oh no, that's too late, you've waited too long. It is not in and of itself an unreasonable delay for a party to wait until TFR to petition a transfer. Because what they've decided is that, there is maybe a good reason why a tribe might leave it within our jurisdiction for the pendency of reunification services, because the social services agency in Los Angeles County may be able to better service the case during reunification. I know that sounds crazy, and it probably is, but in many cases that might actually be the case given the lack of resources that maybe some of these tribes may have. But it's not unreasonable to wait until after for the purposes of permanency planning and placement and tribal connective resources for the child's permanent placement. So just note you can get a motion to transfer at any point in a hearing. And it's not purely in itself an unreasonable delay for it to be past that point. Right to intervene, all you need to know is it's an absolute right. It may be exercised at any point in the proceedings and may be oral or written. That's just when the tribe says, we'd like to be a party in this case. Great, they're a party in the case now. Okay, so active efforts. Now we're getting into the meat of the stuff here. Active efforts finally have been defined for us somewhat. So in any Indian case, any case where the department knows or has reason to know there's an Indian child involved, if they're seeking involuntary foster care or termination of parental rights, then they must satisfy the court that active efforts have been provided. So these are remedial services and rehabilitative programs to prevent the breakup of the Indian family and a showing that those efforts have been unsuccessful. So what did they do and how did it fail, if it did, or why did it fail? It shall be documented by clear and convincing evidence in detail on the record. It's supposed to be assessed on a case-by-case basis. Just like any of our reasonable efforts cases, there's different reasonable efforts for mentally ill parents or developmentally disabled parents or incarcerated parents than there would be for a parent who was not those things. Active efforts should still be conducted while they're investigating whether the child is an Indian child. So again, this should apply from the outset of the case. What are active efforts? I'm not going to read the whole thing, but most importantly, they are affirmative, active, thorough, and timely. That's as close to a definition as we're ever going to get for active efforts. Previous to this, case law had really said that active efforts are really just kind of like reasonable efforts, but like something more. I don't know, but didn't really give you much there. This is as close to a definition as we're going to get, and it definitely should be more than reasonable efforts. I know this is a little hard to read, but I wanted to make sure you had all the stuff here. This is directly from the code and gives you some examples of it being tailored to the facts and circumstances. So for example, it's not just giving referrals to the parents, but going with the parents to the initial assessment. So going with them to their drug program initial assessment or their medication assessment or their mental health evaluation. It's that extra step. It's not just kind of passively sitting back and like maybe the month before the review hearing checking in with service providers. It's calling service providers periodically, checking in. Is it going well? Do they need other referrals? Do they need anything else? Like, essentially, probably monthly contacts with service providers, perhaps. It's visits in family-friendly settings, so probably not the DCFS office in these cases. Settings that are going to be conducive, provided it's all within the best interest of the child and not contrary to their safety or well-being, but not these restrictive DCFS office visits or even visits at like a crowded restaurant or something, maybe more family-friendly settings. You can push these issues with the court. So that's just a couple examples there. Any questions about active efforts? No? Placement preferences. So this one is one that's very near and dear to my heart because of my four-year battle, through the Court of Appeals with a very highly publicized case that maybe some of you might have seen on the news called the Save Lexi saga. But it became a huge thing for me, and I'm like way too deep into placement preferences. So if I'm confusing anyone, please let me know. So placement preferences, what it's important to know is there's an analysis each time there's a change in placement. So that's very similar to our relative placement preference, correct? That, there's a preference prior to disposition and then for any change in placement thereafter. But this means even for the difference between foster care and an adoptive placement, because there are two different sets of preferences under the statute for those two different places, for those two different placements. So even if a change in placement is not technically called for, like the caregiver has done nothing wrong, but the placement itself after TFR becomes now an adoptive placement as opposed to a foster care placement, that's a new analysis. So just be aware of that. When does it apply? Any out-of-home placement, and this is even at detention, so I did put for you the citation for the subdivision in 319 that says it applies even at detention. I believe that's new as well. But the only caveat is that if it's foster care placement or a pre-adoptive placement, then it must be in the least restrictive setting that most approximates family and within reasonable proximity to the children's home. I'm going to give you guys a cite for that I didn't include in here, but Anthony T. It's a 2012 case, 208 Cal App 4th 1019, discusses this exact issue, the reasonable proximity to the child's home during reunification services. As that's important for facilitating, obviously, visitation. Do you have a question?
Where do the expert witnesses come in? Do they come in on a placement?
Stay tuned. They're going to come in at your disposition and a 2-6 hearing for removal or for termination of parental rights, and I will get into that. Absolutely. I was trying to, my hope was, since active efforts and placement preferences apply from the very outset of the case at every point in the proceedings, I wanted to lay the foundation with those. So like I said, there's separate statutes for the adoptive placement preferences versus the foster care placement preferences. The order of preference generally, now I just put on here the order generally, so I kind of combined the two different statutes just to give you guys an idea of what it is, but there is a slight difference. You can reference the statutes yourself if you need to. But in descending order, generally speaking, you're looking at first, a member of the child's extended family. And now that is a broad definition. It can be defined by the tribe's law or custom or brand, or if it's not defined by the tribe's law or custom, any of these specified individuals. Now in my case, the relative was a step second cousin, step second cousin, which would not have been would not have been within the 5th degree of affinity within our relative placement preference or any of those definitions there. However, this person was very involved in the family, and she had been raised by the my client's mother, who was the person who the tribal affiliation descended from. So she was very involved in the culture and very involved with the family, and so the tribe, by their own definition, considered her family. So that's why she was a first order of preference. In Ray Brandon M is this case that just says that de facto parents can be considered as extended family. It doesn't limit the, it pretty broadly says de facto parents can be considered, but I would, if you're faced with this situation, distinguish the facts of this case. I thought it was a pretty unique case, whereupon the person who was de facto was the former stepfather. So he would have been formally defined within the actual statute. He also was approved and considered family by the tribe, but the court went so far as to say that even all that considered, a de facto parent could be considered. But I would just limit it to those facts and circumstances, because I mean, I know how troubling it can be if foster parents get de facto parent status and then they're saying, well, we're extended family because we're de facto parents. I mean, if the tribe is going to join with them in that assessment, then you're going to be in trouble because of this case. If the tribe goes against them, that's what I was faced with in my Lexi case. They were de facto parents. Foster parents achieved de facto parent status, but the tribe was not in supportive placement with them. The tribe explicitly did not define them as family. So that's important to note and an important difference.
It's basically whoever the tribe wants to designate.
Yes, if they choose someone, otherwise it's somebody defined within the statute. But basically it's going to be who the tribe wants the kid to be placed with. Other members of the child's tribe or other Indian families are the other preferences. The exceptions to this are really limited. It's another order of preference is established by the tribe, so if they usually have to have like a written rules that say that they have a different order of preference in place, or good cause exists to deviate from the preferences. And just know that for the foster care order of preference, there's also included in here a foster home approved by the tribe. So this is just, because we're here about bias, a little bit of an idea as to what I dealt with in this case and what really is still existing in the public eye in terms of these cases where you're battling over placement with relatives or in some cases foster parents who the children have been placed with for maybe a lengthy period of time. I understand, like, these foster parents, until they did their job. They were doing their job. They took great care of this child. But we were faced with this battle that was then taken into the media, and these are just some of the headlines that came out that I just pulled these straight from the internet. Important to note, 1.5% Choctaw Indian, irrelevant. Percentages, blood quantums, not important. A child is either an Indian child, as defined by the tribe, or they're not. We do not care, once the tribe defines them as an Indian child, how much percentage they have in them, how connected they are to the tribe, how involved their family was in tribal activities or cultural events, or whether they receive. One of the things they wanted to question my client about was whether he received the tribal newsletter. These things are irrelevant. Once the child is defined as an Indian child, they are an Indian child. And what's missing from every single one of these headlines is that not only was she 1.5% Choctaw heritage, or Native American, or part Choctaw, as they say, she was actually a registered member of the Choctaw tribe. So she is a citizen. She's a Choctaw citizen. That's what this should have said. And she was not being removed from the only family she's ever known. She was being placed with family who she had a relationship with. So I just want you guys to be very cognizant of the way that we are addressing these issues and the way that these cases are sometimes framed in the media. The foster father, himself trying to say they're moving her to a family that's not Native American. The placement preferences, you guys, don't apply to extended family members who are Indian. It's extended family. So the extended family member does not have to be a member of the tribe. The extended family is defined as whoever they believe is part of the social and community support group for this family. And it's not defined so narrowly as to be Native American individuals. And that's a common misconception that people have. They think that like, oh, well, if the ICWA applies, then like maybe you have mom who doesn't have any Indian ancestry, but dad has Indian ancestry. She hates dad's family. And she's worried, well, if the ICWA applies, then they're going to have to place them with my in-laws? Not necessarily. I mean, that is something that could happen if they're appropriate and they do seek placement and get approved. But it would provide a placement preference for her relatives just as strong. So that's really something to be aware of. Just so you guys know, in this case, it was important to note that the tribe approved the foster parents for placement during reunification services. So we were up against the whole reasonable proximity during FR issue, right? Because these relatives that I was seeking placement with during permanency live in Utah. So we were not seeking placement with these relatives at the time when the case was in its reunification. And properly so, the court was aware of them, made findings to deviate from the placement preferences during reunification for the purposes of a foster care placement to approve placement with these foster parents. However, that tribe identified that for the purposes of adoption, these relatives in Utah are ready, willing, and available to adopt this child. So once time came that FR was terminated, it now shifted and the preferences renewed, and that's when this battle began. The battle began at that point because then they're like, well, she's been in our care for, was about 10 months at that point. And they were just so attached that they were not ready to let go of her. So 10 months was when the good cause trial started, and 3 years later, after 3 different reversals and remand trials, the child was placed with relatives. Good cause to deviate. The party asserting it must provide the reasons orally on the record or in writing to the parties and the court, and bears the burden by clear and convincing evidence. So this is new. The burden part is not new, but providing the reasons orally on the record or in writing is new. They do need to specify exactly why they're asking for good cause to deviate. It should be very clear. And if the court is going to find that there is actually good cause to deviate from the placement preferences, it needs to be on the record or in writing, so a written decision or statement, and shall be based on one of the following things here. So it can be the request of one or both of the parents. What they've added here is that it's if they attest that they've reviewed the placement options and they know what placement options are available for those that comply with the placement preferences. It can be based on the request of a child, but that's only if that child is of sufficient age and capacity to understand the decision that is being made. There's no definition for what that age and capacity is, but frankly, I would analogize it to the case law that says that there's an exception to adoption for a child aged 12 or older who says that they don't want to be adopted. There's probably a reason the legislator picked that age, because it takes some sufficient capacity to understand what that means, what adoption or legal guardianship means. So, you know, if you need to, that's one analogy you can make or an argument you can make. They've added in here the presence of a sibling attachment that can be maintained only through a particular placement. So maybe there's a preferred placement with a relative who's in another state, but these parents had already had lots of other children who are in a foster home here in LA County, who's willing to take just one more of the siblings because they'd like to keep them together. And that's the only way that they can maintain this attachment. Well, now you need to consider, is there actually an existing attachment there or not? If this is a newborn child, was there actually an attachment? So it really does mean an attachment that exists. So there better have been at least some visitation or contact. If it is a newborn child, I think you can get around that argument. Extraordinary physical, mental, or emotional needs of the Indian child. That's a pretty high burden as well, and it really does mean extraordinary, okay? So it's not just that, well, they're just really attached to their foster parents, because children are resilient, and attachments can be reformed. So it needs to be something pretty severe, or there's maybe special treatment that they need for a medical condition that is not available in the area, you know, where the placement is being sought, or unavailability of a suitable placement after a diligent search was conducted. You may not depart from the preference based on the socioeconomic status of a placement relative to another. That seems pretty common sense, but they had to put it in here. And you may not depart from the preferences based solely on ordinary bonding or attachment that flowed from time spent in a non-preferred placement that was made in violation of ICWA. Now, what's important to note is that that's in violation of the ICWA. So that would be a case where maybe there was a failure to properly notice that resulted in a delay in determining if this child was an Indian child. In my case, where the tribe agreed to placement during the FR period, with the idea that adoptive placement would be with the relatives in Utah, that placement with them, the bond that they established with them during that time during FR, is not ordinary bonding or attachment that flowed from time spent in a non-preferred placement made in violation of ICWA. So technically, the court probably could have considered that if it rose to the level of maybe meeting the extraordinary physical, mental, or emotional needs of the child. Does everybody understand the distinction I'm making there? Okay. So it's going to be pretty rare. They are going to talk about bonding and attachment when they're talking about moving a child from one caregiver to another, unless it was really done in violation of the law. Disposition. So in disposition, we recently had a case in Ray Colony, just came out, 2018, a couple months ago, where they talk about evaluating the totality of the circumstances in making these determinations, and that continued custody does include both legal and or physical custody, so there's no argument to be had there. In that, well, I'll let you guys read it since I'm short on time. The court may order an involuntary foster care placement only if it determines by clear and convincing evidence, and now here's where your qualified expert witness comes into play, including the testimony of a qualified expert witness, that continued custody by the parent or Indian custodian is likely to result in serious emotional or physical damage to the child. This is actually a pretty similar standard to our normal removal standard under 361 for non-ICWA cases. The biggest difference being that it does require testimony of a qualified expert witness. So, same thing for termination of parental rights, except for here's where the burden of proof all of a sudden jumps up. Criminal standard, beyond a reasonable doubt. You cannot terminate parental rights for an Indian child unless the court determines, based on evidence beyond a reasonable doubt, including the testimony of a qualified expert witness, that continued custody by the parent or Indian custodian is likely to result in serious emotional or physical damage to the child. So get your 388s filed in these cases if you have them. There are some exceptions to adoption that are unique to Indian cases as well. If the child is an Indian child and termination of parental rights would substantially interfere with their connection to their tribal community or their membership rights, or if the tribe has identified a different placement arrangement for the child. So those are some things to keep in mind. What is a qualified expert witness? Now, both of those statutes said testimony. That requires live testimony from a qualified expert witness. That can be on phone or in person, but the only way it can be in writing is if there's a written stipulation. That's pursuant to 224.6E. That written stipulation must be given knowing intelligently and voluntarily from your parents. It's essentially a waiver of their rights. So just note that that's going to be live testimony. So why would you stipulate to that? Are there cases we would stipulate to it? Sure. If you've got a settlement and it's a good settlement and you have a good reason for stipulating that, okay, we're going to submit on suitable placement, FR, maybe you stipulate. But think of this like the department's expert. Are you just going to let Dr. Imagawa submit a report on your e-case without cross-examining her? Very unlikely that you would. I can't think of many cases in which you would, unless you really had nothing. So this is their expert. This is their person who is putting forth their position. Don't forget to cross-examine them. Who's most likely to qualify? It's the exact same people that were under the code before. They've just eliminated. There used to be a section that said anyone who has experience in child welfare practices. So Dr. Crespo one time testified on an ICWA case. They must be qualified to testify about both the cultural standards, social and cultural standards of the Indian child's tribe, and the legal standard that is required under the statute. So these are just some things, some suggestions of what should an expert know. Same kind of things that we're going to be doing when you're cross-examining experts in your other cases. You know, do they know some of these particular issues that are relevant to the Indian child's needs, the tribe services, cultural expectations, child rearing in the tribe, the definition of family in a tribe? Was this a case where they said that the child was left unsupervised or with strangers or in an inappropriate plan? Is it really an inappropriate plan under their tribal understandings and cultural expectations? Laying the foundation, same thing that you would for any expert witness. I'm not trying to give you guys an expert witness training here, but lay the foundation for their qualifications and backgrounds. A lot of times these experts are going to be actual members of the tribe, so it shouldn't be that hard to get into why they know the actual cultural and social practices of the tribe. But make sure that they also know the child rearing practices, services available, family structure, and who did they talk to? Did they just get a packet of department reports and provide an assessment? Or did they interview the parents? Did they know that your client was in any programs? I've cross-examined expert witnesses, Indian expert witnesses successfully before. My client, their recommendation was no FR. She was enrolled and almost completed with a full substance abuse program. They had no idea, not a clue. Changed their recommendation on the record. So make sure that they know something more than what's being passed to them through the department's reports. Tribal customary adoption probably really doesn't interest most of you. It's essentially, it's not much different than adoption as we know it in our other cases, but it allows for continued family and tribal connections. In many Indian cultures, termination of parental rights is a positive to their cultural beliefs and practices. So, what does it mean? At any 2-6 hearing in an ICWA case, the court has to find that the department in fact consulted with the tribe and they were involved in the plan, including a consideration of this. They have to consider it. They have to consider the alternative to termination of parental rights. Another very recent published case, this is just like about a month ago or so, addressed the very specific issue of tribal customary adoption. In this case, the parents were very much opposed to tribal customary adoption. And they really felt like their due process rights were violated in their lack of ability to kind of address why they thought tribal customary adoption was not appropriate in this case. The court did an analysis of due process just being an opportunity to present relevant evidence, and in that case, the parents did have an opportunity to testify. The court allowed them to testify, even about some stuff that was questionably relevant. So the court found that they did have the opportunity to present their relevant evidence, and they also testified about their communication with the tribe in their testimony. So the important thing, if you see tribal customary adoption being recommended in a case of yours, talk with your client. did they have a conversation with the tribe about tribal customary adoption? Because it is a requirement under the statute, under C7, 366.24 C7. It does require that the tribe actually have a consultation and discussion with the parents about what tribal customary adoption means, what their position is regarding that, and they have to be part of developing the order and completing the tribal customary adoption, because it can involve a provision for visitation beyond the adoption, essentially. So that's why that is there, and I'm happy to answer more questions about tribal customary adoption if anybody has them, but it can get real convoluted and detailed. This statute 366.24 is very long, so I recommend you read it if you have a case. Does anybody have any questions about the new law? No? No questions whatsoever?
Well, Commissioner Padilla said that she did a training for all of the judges, so I'm hoping it's on the new law, and I hope they listen.
Yeah, I really do. I am curious to see how these new timelines and additional findings are going to play out in the court. So if anybody wants to keep me informed as to how it's playing out, I'd be curious to know. And if anybody has any questions, I'm always happy to be a resource. And I can send out my part 1 for anybody who needs it if they weren't able to be here.
Thank you, Jessica.
Thank you.